Please be seated. Welcome to the First Court of Appeals on October 12th, 2022. We have only one case set for oral argument today. Case number 0122000079CV, Harris County versus Levent Dogan. Can I have appearance of counsel for the appellant, please?
Good afternoon, Your Honor. Vaughn Waters, a law firm here on behalf of appellant Harris County.
And you've been allotted 15 minutes, so you can reserve time for rebuttal.
Your Honor, if I may, I would like to spend approximately 10 minutes on initial presentation and reserve the balance.
All right, 10 to 5 will do. And counsel for the appellee.
Good afternoon. Caldwell Fletcher, counsel for Levent Dogan appellee.
Thank you. When you're ready, Mr. Waters, we are.
On behalf of Harris County, may it please the court. At bottom, this is not a particularly novel or complex appeal. The legal principles that govern it are fairly plain and have been plainly understood in Texas law for some time now. I will not spend a great deal of time on the facts, as I'm sure the court has already reviewed the briefs and is generally familiar with those, but only insofar as we need to set the matter in some context. This is a case arising out of a workers' compensation claim involving a heart attack, and I stress a heart attack that was suffered by Mr. Levent Dogan on March 9th, 2016, while he was in training to become a corrections officer for Harris County. All parties agree that the claim was submitted to the Division of Workers' Compensation, and it moved through the administrative levels of DWC and into judicial review on two issues, and two issues only. And because the exact wording is important, I will recite them here. Number one, did the claimant sustain a compensable heart attack on March 9th, 2016? And number two, did the claimant have disability resulting from the claimed injury?
So just a question about the trial mechanics. So we get to judicial review after the Commission on Appeals has ruled. And my understanding is that is a modified de novo approach?
Correct.
And what precisely is meant by modified de novo?
Modified de novo is, I believe, as I understand it, has to do with the fact that some deference can be given to the findings of fact and conclusions of law that were entered by the division in this case. And that has usually been the case. In fact, that findings of fact can, in some instances, be considered by the court in favor of the prevailing party at the administrative level in the trial court.
So if to be accorded some deference, is it presented to the jury? Is the jury informed about it? Is it entered in evidence? What happens with those findings? How is the jury informed?
My understanding is that the jury can be informed of the findings. In this case, there were certain findings entered, but since they involved the absence of compensability, no compensable injury in the case, because of that, the findings of disability, any findings that may have been inferable, for example, from finding of fact number 6, which became an issue later on in the case, those become moot. At any event, there was substantial evidence and disputed evidence presented on both sides. There were two different medical experts who testified, one for Harris County, one for Mr. Dogan, and the jury presumably weighed that testimony and made its findings based on that testimony as to the compensability element. The disability element was never, of course, submitted to the jury because no question was requested or submitted concerning disability.
Was it ever in dispute?
Your Honor, the counsel for Mr. Dogan at the trial level submitted I guess an email, a communication shortly before trial to Harris County's trial counsel, Mr. Singley, indicating that he did not consider it to be in dispute. We certainly considered it to be in dispute, and it was in dispute because that was what was submitted to, it was one of the issues that was specifically submitted to DWC, and DWC specifically found that there was no disability. There could not have been disability because there was no compensability.
Was the party challenging the findings of the administrative findings bound by those discriminative, precise wording of those findings, or can, if it's a trial de novo, why does the fact that it was considered by the during the administrative process bind or otherwise affect what's going on in the trial de novo?
Well, I think we can look at that in terms of whether we have competent legal evidence in view of what happened at the administrative level. That was one of the cases that we discussed, of course, in our brief, SORM versus Martinez, the Texas Supreme Court case in recent years, in which it was held that if you have findings of fact that tend to indicate a certain proposition on compensability or disability, which are rendered moot by other findings and by the conclusions of the law, those findings that were rendered moot no longer qualify as competent evidence. Now, that is one of the issues that we raised here in support of our argument that findings on disability could not be entered here. Certainly, the findings that are entered in the administrative level at DWC are not absolutely binding on the trial court. Modified de novo certainly does not go that far. And in our case, we had a situation in which a finding of disability was actually entered by the trial court purportedly under Rule 279, which was erroneous because we did not have in this case a missing element of disability that was not submitted to the jury. We had an entire missing theory of recovery, namely disability, none of which was submitted to the jury in this case.
How is that a distinct, separate theory of recovery when the theory, the compensability depends on two different elements, right? It depends on there being an event and then a disability arising from that event. That's sort of like all one theory.
Well, actually there is case law to the contrary, Your Honor, that we discussed in our brief arising out of the Texarkana Court of Appeals. It was an older case, 1935, that spoke rather plainly on the issue. Now, compensability involves a finding of an injury which is sustained in the course and scope of employment, and if the injury, as in this case, consists of a heart attack, there are two additional findings that must be made concerning the substantial contributing factor of the work itself, as opposed to underlying conditions that might have contributed to the heart attack.
So, I understand, Marbury versus Madison is an old case and it's still viable, but in 1935 Texarkana case, when we've had complete overhaul of the workers' compensation system a couple times since then, it just seems to me that that might be a slender reed upon which to find 279 inapplicable.
Well, Your Honor, if compensability deals with entitlement to medical benefits, as is the case, and disability requires both a finding of compensability and a finding that there is an inability to obtain or retain employment at pre-injury wages, which is the essence, I suppose, of disability. It's hard to see how Rule 279 could apply to say that, well, this is just one element on top of another, and we can always supply that. I mean, it's a bit like arguing, I suppose, to use an example, that you could enter a deemed finding under Rule 279 of gross negligence, when the only thing that was submitted to the jury and the only thing found by the jury was simple negligence. Because after all, you have to have simple negligence to make gross, and the Chapter 41 elements, act or omission, which we viewed from the standpoint of the actor, et cetera, are just additional elements that we add on to the simple negligence. But respectfully, I don't think it works that way. I don't think a trial court would be able to do that with gross negligence. Here we have two independent theories of recovery, and it's perhaps worth pointing out that the Great American versus Jordan case has not been questioned or overruled on that point at any time since. I think we're dealing with a fundamental issue of what constitutes theories of recovery. The Jordan case involved, I believe, three findings of fact that were entered. There was, number one, was there an injury which was incurred in the course and scope of employment? Number two, was there total disability resulting from that injury? And number three, was the injury itself permanent in nature? And from those three findings, which included total disability, the court concluded that we could not enter a deemed finding under Rule 279 of total permanent disability. Now, quite frankly, I don't think we need to go anywhere near as far as the Texarkana court did in Jordan in order to arrive at the conclusion that compensability and disability are two different theories of recovery. They simply involve entirely different elements, even though one happens to be dependent on the other.
What should the second question have looked like?
I'm
If
sorry?
submitted properly, what should that question have looked like, submitted to the jury?
If submitted properly, it would have been something along the lines of what was considered by the DWC in that. Did disability result from the compensable injury, if you have found a compensable injury, and was the disability total or partial, and for what dates? I would think something along those lines. But that was never requested, and it was never submitted. And of course, the record does not conclusively establish that disability was incurred. The only thing other than the moot finding of fact number 6 that I think was referred to by Pelley in briefing was the sheets indicating that the appellee did not work for a certain period. Well, that's evidence that the appellee did not work for a certain period, but it's not evidence of inability to work.
So we're talking about 4 months of disability payments here?
I believe so. I believe that's correct. March 10th to July 10th
And
on disability.
You know, we understand that every case is important, no matter the dollar figure attached, but what is the dollar amount that we're really talking about here?
Your Honor, I would be, to be honest, I would be speculating if I were to submit a dollar amount on the disability there. And I would not want to speculate for the simple reason that I would not feel able to give an informed opinion on what other effects that might have. I mean, I come from a background where I used to work as a JAG officer in the Navy in the Physical Evaluation Board. And the rule was that if you got any percentage of disability assigned by the PD board, it carried certain benefits and collateral effects that had nothing to do with the number on it. So
Okay.
I would not feel confident to speak to that. However, I would say, Your Honor, that in looking at this issue, I think it is simply a stretch to say that these are not two separate theories of recovery, given that the elements that relate to each, other than disability being dependent on compensability, are completely different. There was nothing submitted to the jury by which the jury could have found that there was an inability to obtain and retain employment at pre-injury levels for any period of time.
Okay, we have your argument, Mr. Waters, and now Mr. Fletcher gets a chance.
Thank
So,
you.
Good afternoon, may it please the court. On behalf of Mr. Dogan, on the issue, well, first of all, let me say, in answer to the question, Appley has a different take on what modified de novo is. I think you're able to review factual and legal findings that have to do with eligibility and availability of benefits under a trial de novo standard, and then other issues that may be miscellaneous issues are reviewed under the substantial evidence rule. So that's what I believe modified de novo means. The question is not whether there was a dispute going forward before the jury and the court on disability, but on what basis the appellant was entitled to defend. We pointed out that finding of fact number 6 on the clerk's record, page 84, said that the hearing officer found that Mr. Dogan was unable to work for the period of time at issue due to the heart attack. So there was no other reason that he was able to work. The missing facts that would support a disability finding were compensability facts. And the jury found in Mr. Dogan's favor on question 1 in that regard. The carrier is only entitled to defend based on its controversion of the legal issues and factual issues. And trial exhibit number 1 for Mr. Dogan was the original controversion that was filed in the administrative agency. And there is a rule that we cited in our brief that provides that the carrier is limited to that, and if there's any basis, they need to state it in their controversion, and it cannot just be conclusory. In this case, the conclusory nature of the controversion filed with the administrative agency just said there is not disability under the Texas Workers' Compensation Act. That is precluded by the rule we cited.
well, let's talk about the Martinez case for a second, and the on the legal effect of the hearing officer's determination. Martinez seems to say that you're not allowed to just pick and choose which ones you rely on to cherry pick the finding. And isn't that what you did here? Or is the way that Martinez could be distinguished?
So Martinez confirms that judicial review is on issues decided by the appeals panel, and the onus is on the appealing party, which must rebut the decision of the hearing officer, or findings of fact for which insufficient evidence exists. On disability at the administrative level below, the only factual element missing from the disability claim were those facts supporting compensability, the same facts that the jury decided and the court entered judgment on. If there were other facts required by the self-insured Harris County had the onus of putting in a non-conclusory manner in the controversion. Instead, they pled a conclusion, and a conclusion was not upheld by the hearing officer in the decision and order. So they didn't appeal that finding of fact, And I don't think that's cherry picking, because essentially once you find compensability and an unappealed finding of fact, you have a person that is disabled under the Workers' Compensation Act.
What is your best case for that proposition?
Well, I kind of like Martinez for that proposition, Your Honor. I think that it's not necessary to distinguish it as the appellant suggests, and I believe that if you look at what happened after the, or during and after the trial, we entered into a Rule 11 agreement, which is part of the court's record here, which basically said we agree to go to the administrative agency on the issue of follow-on injury. And that's a second heart attack that Mr. Dogan had on March 15th, 6 days after this injury. Both experts testified it was related to the effects of the first heart attack, which the jury has found. So we agreed to go back to the administrative agency on that. Clearly, if that's certified, then there's going to be a separate period of disability that would go to the administrative agency. And why should they be tasked with having to decide that when it's already been decided here? I'm willing to do that, and it would only cost Mr. Dogan 6 days, but I don't think we should have to do it again. Could I address the issue, Judge, of the second point of error on the jury charge questions 1 and 2? The Barnes decision of this court, which is cited at footnote 2 on page 18 of our brief, requires the jury to weigh between the conditions leading to the heart attack, applying Texas Labor Code 408.008. In this case, there was evidence from Dr. Ott, who was the expert for Mr. Dogan at trial, who said that the heart attack likely happened in one of two ways. It happened either from what we call in the brief a traditional heart attack, where there's a piece of plaque that breaks off in an occlusion, or he said it happened from a shear force tear in the vessel, which then clotted, causing the same symptoms of a heart attack. And given the fact that Mr. Dogan was almost immediately catheterized after this heart attack, it's impossible to tell which, but that was his opinion. So it's our position that surely as a matter of fact, the judge was entitled to submit question number 2 to the jury because there was evidence that Mr. Dogan's heart attack had happened not as a traditional heart attack, which we submitted to the jury in question 1, but as a result of the shear force heart attack. And luckily, the court didn't have to rely on that because of the affirmative answer of the jury in question number 1. And so it's our position that this was a correct disjunctive submission by the trial court under Rule 277. And we might have a closer case if the jury actually had to answer no to question number 1 and yes to question number 2, then there might be a jurisdictional issue about whether that was a theory that was advanced by the way the hearing officer phrased the original issue at the administrative agency. But luckily we don't have to determine that there's a jurisdictional issue because the court is entitled to ignore immaterial matters when entering judgment. This court in Ruff versus University of St. Thomas, 582 Southwest 3rd 707, confirmed that when entering judgment, the court may disregard an immaterial question when entering judgment, relying on Rule 301. And in that case, it involved parental negligence and the parental privilege. And so that decision also confirmed that this court felt that the proper way to look at the question of immateriality was reviewed de novo. And I assume that that's continues to be the court's position.
May I ask a question?
Yes, sir.
So on this judgment, kind of going back to Justice Kelly's question about the amount of disability benefits that would be paid. So obviously there were no findings of an amount in this judgment. So do the parties agree? Do they already know what the amount is, or how will that be determined?
I can tell you as a workers' compensation practitioner, Your Honor, that the answer to that question would come from a couple of places. It would be when the adjuster for Harris County actually pays benefits, we would have to look at how they were calculated, and by doing that, we would look at the wage statement that's provided by the employer, and the disability period is figured by 70% of the average weekly wage of Mr. Dogan as a jailer trainee and what he was earning at that time. And that would be his comp rate. And in this case, as the court pointed out, we're looking at about 4 months of payments. So I agree with counsel. Until it's paid, we can't know the exact amount, but we do know it's limited to that duration. And I'll represent to the court in the follow-on injury that Mr. Dogan is not seeking temporary income benefits beyond that 4-month period, because he did return to work at that time.
So in addition to being curious about the amount at issue, I was also making that inquiry because I was curious if that is something that usually is a fact question for the jury, and so I sort of wanted your, I guess, information on that and whether that would have been the usual course, but I guess it sounds like it's not.
So if there was a dispute on what the average weekly wage was and therefore how the benefits were calculated, that would need to be brought up at the administrative agency. It wasn't part of this record, so that wasn't something that had happened yet. So Mr. Dogan doesn't know if there's a dispute on that or not.
Are there any further questions from the panel? Thank you very much. We have your argument.
Thank you, Justice Kelly.
Briefly, Your Honor, for purposes of rebuttal, I will address primarily, if I may, the second issue, which I did not reach, the second point of error regarding the submission of the charge. We have discussed Harris County's position on the disability issue, what should have been requested and submitted but was not. The other issue involves what was submitted but should not have been, we respectfully submit, and that is question number 2. Now, this court has, of course...
Well, let's go to the harm analysis on that. And how did that cause the rendition of an improper judgment?
Because you have 2 different standards that are applicable to these questions, Your Honor. The heart attack question, it is a standard question, 408.008 of the Labor Code does not draw distinctions between traditional or non-traditional or rupture plaque or diffusion tear of the arteries. If it's a heart attack, it is submitted in a certain way. And in the Barnes case, decided by this court, as was cited by counsel, the court made it very clear that heart attacks are a special case. They are sort of sui generis under the Texas Labor Code and Workers' Compensation Act in terms of how they're submitted. It is not enough that it be incurred in the course and scope of employment. There are additional factors that are required, the substantial contributing factor of the work itself in causing the heart attack. When question number 2 was submitted to the jury, Your Honor, and we will assume, as I think we must assume, that the jury followed the court's instructions, the trial court's instructions, and considered all parts of the charge when it went back into the deliberation room to decide on the appropriate verdict. And when it looked at question number 2, it was faced with answering a question in conjunction with question number 1, which was framed differently. All that was required for an affirmative answer.
Was there any predication on question number 2?
I'm sorry?
Was there any predication? Was it, if you answered yes to question number 1, you don't have to answer
There was
question
not.
number 2?
There was not, Your Honor. They were simply 2 separate individual questions that were submitted. And question number 2 was the usual and customary injury question. Was the injury incurred in the course and scope of employment, not in any way related to heart attack?
Right. Did it not include the specifics of the heart attack question?
Right. It did not include any of the all.
But how did that cause the rendition of an improper verdict?
It led the jury to believe, or at least it had the potential to lead the jury to believe that it could answer affirmatively to an injury based on question number 2. That it could simply consider whether the injury was incurred in the course and scope of employment and base its finding on that. At the very least, Your Honor, when you have a question submitted like this, in which the jury has 2 alternative ways to arrive at a finding of compensability, one of which involves the correct high standard route and the other involves the incorrect, more lenient standard route, that is an invitation to confusion in the minds of the jurors.
And that makes it, I'm having trouble wrapping my mind around that, having a broader question. I mean, take for instance in a standard tort case, you have, I don't know, let's say it's there's a question of law as to whether it's Chapter 95 or just a regular tort case, right? Mm-hmm. So you submit it once as just a regular, did the negligence of defendant approximately cause injury? Yeah. But it might also be a Chapter 95 question. So instead of having this whole second trial, you have your second liability question incorporating that defense, right? So you ask liable generally and then also liable under Chapter 95. How does the liable question, let's say the reviewing court later says it's a Chapter 95 case. Well, you don't have to retry the entire case because there's a general question up front that doesn't incorporate the defenses.
Well, the distinction, Your Honor, I think in the case that you have hypothesized here would be that there might very well be a need in such a case as between regular negligence and Chapter 95, depending on the circumstances, to arrive at a finding that might pertain to one or the other. Here, again, we are dealing only with a heart attack, and we are dealing with a statutory framework not present in the other example, in which any injury must wend its way first through DWC.
Right. So for the plaintiff to prevail, they have to get a yes answer to question number 1, right? And question number 2 here is irrelevant. It doesn't matter if they got a yes or a no, because they can't recover. So isn't that the very definition of an immaterial question that we can disregard?
Well, we would respectfully submit, Your Honor, that when the question is framed the way question number 2 was, with an incorrect standard, and which the jury, we must assume, considered in conjunction with question number 1, after it retired, we think the potential for prejudice is simply too great. How is a lay jury supposed to come to the conclusion that question number 2 should not have been submitted in the first place?
Do you have any authority for that proposition that the submission of an immaterial or too broadly worded question will infect the finding of the more specific question?
With respect to a situation such as that in which the question involves workers' compensation compensability of a heart attack, our authority, Your Honor, respectfully is 408.008 of the Labor Code, and also the Barnes case, in which it was realized and recognized that heart attack is a special and unique situation.
Right, but I'm talking about the very specific question of whether it is reversible error, whether the asking of the incorrect general question is so erroneous, it will cause a rendition of an improper judgment. Do you have any authority for that proposition?
Dealing specifically with a heart attack, I do not, Your Honor.
Not even dealing specifically with a heart attack. I mean, just in any context.
I have not come across that.
Okay, so I mean, basically what you're doing is asking us to presume harm for the asking of an immaterial question. And just so you know, I'm a little bit leery about extending the authority of this court to presuming harm in a place that has not been suggested in Texas jurisprudence in the past. Any other questions? Okay, thank you very much for your time. Cause number 0122000079 Harris County versus Levent Dogan is submitted, and the First Court of Appeals is adjourned. Thank you for your time.
All right.